Welcome to Employment Law This Week. I'm George Whipple. On April 1st, 2020, the Families First Coronavirus Response Act went into effect, establishing an emergency paid leave program in response to the COVID-19 pandemic. The Department of Labor has published temporary regulations that help provide clarity to employers on the FFCRA. Epstein, Becker Green's Lauri Rasnick is here with more details on the regulations.
The DOL temporary regulations clarify that employees who are on furlough or who are not working due to a lack of work are not eligible for emergency paid sick leave. So what that means is if you have an employee who's currently receiving employee emergency paid sick leave, and that employee is furloughed or ceases work due to a lack of work, that employee should only receive the emergency paid sick leave through the date of the furlough or the closure. The first reason is where an employee is subject to an isolation or quarantine order. The division has explained that such an isolation or quarantine order can be read fairly broadly. So it would include, for example, a shelter in place, a stay-at-home order, another order by a governmental agency where employees are limited in their mobility. If an employee can work from home through telework, that employee will not qualify for the sick leave. If that employee cannot work because that employee is subject to a furlough or a closure of work or a lack of work, that employee also will not qualify for the emergency paid sick leave. The regulations state that employee eligibility for expanded FMLA depend on how much FMLA leave an employee has used within the applicable 12-month period. Employees eligible for FMLA leave are able to take 12 weeks of FMLA during a 12-month time period. The regulations explain that the expanded FMLA provisions do not provide more than 12 weeks. The other piece that the regulations have given more guidance on is the initial unpaid time period under the extended FMLA provision. The law provided for the unpaid provision to last for 10 days, but the temporary regulations explain that it really needs to be a 2-week time period that is unpaid. And this accounts for employees who have irregular time schedules to ensure that they do not receive less pay or too much pay. An employer is required to keep records of all requests and denials of leave, all documentation provided in support of a request for leave. If an employee provides information to an employer orally, the employer is required to document that information and also retain that documentation. All of that information needs to be retained by the employer for a 4-year period. The 3 exemptions are as follows. 1, where the employee's absence was caused the employer's expenses or financial obligations to exceed the business revenue and essentially cause that employer to cease operational minimal capacity. 2nd is where the employee's absence would pose a substantial risk to the employer's business because that employee's has special skills, holds a special role, has particularized knowledge that the employer cannot otherwise have access to. The 3rd reason is where an employer would be unable to find an employee or employees who would be able, qualified, and capable of doing the work at the proper time periods and dates to fulfill their work and have that employer function at the minimal capacity. These exemptions only apply to situations where an employee is seeking extended FMLA leave, not for the emergency paid sick leave. If an employer believes that it has an employee seeking leave and can justify one of these exemptions, the employer needs to have an authorized official document the criteria that satisfies the exemption, and that documentation needs to be maintained for 4 years.
Thanks, Lauri, and thank you all very much for watching. We hope you're all staying safe and healthy, and we'll see you next time.